This conference will now be recorded.
Bill, it's Don Elliott. Where was your column? I didn't see it.
In notice and comment, the Yale Journal regulation
Great,
online.
thank you. Thank you.
Matt, my clock says that it is now noon. Do you want us to go ahead and get started, or do you want to wait a few minutes for people to continue to trickle in?
I'd like you to do whatever suits you best, Kristen.
Well, why don't we go ahead and get started then? I think, so my computer or my streaming keeps freezing. I don't know about anyone else's. I know that my understanding, and Matt, Bobby, correct me if I'm wrong here. My understanding is that having everyone's video up slows things down. Is that right?
Jennifer, are you on?
Yes, I am. It would be best.
Would it be helpful, Jennifer, if everybody turns their video off?
Yeah, there's no voting going on. It'd probably be best just keeping the videos of the consultant and the committee chair and the ACA staff member assigned to the project.
Okay, so as much as I like seeing people's faces, in order to keep the stream from freezing, which I know was a problem in a meeting I was in earlier, why don't we just all turn our video off? Thanks for that. Hate it, but that's where we're at. So with that, let's go ahead and get started, since it's noon and we want to, or noon by my clock, 1 o'clock Eastern time. In any event, we're going to start with opening remarks from Matt. Please go ahead.
Very briefly, opening remarks mostly by way of thanks. First of all, thank you, Kristen, for chairing the proceedings of yet another project this fall. You've already got one under your belt. I hope this isn't too heavy of a lift, and I hope this is a pleasant one, especially since there'll be no debates and voting. Secondly, I would like to thank John Siegel for taking on this very large project and for preparing the source book, about which he'll, I'm sure, have a few words to say. I think this will be an extraordinary contribution to ACUS's body of work, and it will be very, very useful, not only to congressional staff, one of the main audiences, but also to the judiciary and the public and agencies and so forth and so on. Then the last thing I would say is that I would expect that this source book will beget a number of projects for this committee, directed to the formulation of an assembly recommendation. And today's meeting will address one potential recommendation project, and that's sort of call it a statutory housekeeping project on judicial review. And my intention, unless I hear something that would suggest it's not a good idea, would be to proceed with a recommendation project with respect to the subjects we're going to discuss today. And of course, that's subject to the consent of our counsel. Last thing I would like to say, just by way of thanks, the research for this project was done by the ACA staff, or a lot of it was done by the ACA staff under John Siegel's guidance, as well as Reeves' guidance. Every member of this, I think every one of our attorney advisors, I think every one of our attorneys, including myself, did some of the research. And basically, we slogged through the entire United States Code to identify every provision governing the judicial review of adjudicative orders and agency rules. And so I would like to acknowledge the work of the staff. The research for this project resides in a spreadsheet in our offices, and we will at some point put it online as a companion to John's source book. So with that, I will turn it back over to you, and have a good meeting.
Thanks so much, Matt. I appreciate it. And I should have said before, welcome everybody. I appreciate everybody taking the time to be here today. This is a fantastic turnout for discussion of what I think is a great project. And so I'm looking forward to hearing everybody's input. I'm going to dispense with the reading of the, sort of general rules for voting and participating in the discussion, since we're not voting on anything today. And I think today's discussion is a much more casual one than we have when we're considering formal recommendations. The only thing that I will say in terms of rules for conducting the meeting, number one, for those of you who are joining us a little bit after we got started, because we're having some technical difficulties just making sure that the stream remains uninterrupted. If you wouldn't mind keeping your video off to the extent possible, that will keep everything from freezing. The other thing I will suggest is that if you want to add your name to the queue, if you want to participate in the discussion, you have a comment or a question, something to add, please just signal me in the chat, and I will keep a queue to the best of my ability. Of course, you're also welcome, I suppose, to turn on your camera and wave your arms at me if the chat's not working for you, or I know that some of you are participating by phone. And if that's the case, then of course feel free to break in at some point just to let us know that you've got something to add. For those of you who are online, if you can just signal me in the chat, I'd like to try to keep the queue somewhat orderly. What we should not do, however, is use the chat for substantive discussion. From my understanding in GoToMeeting, the chat is not saved and it can be somewhat distracting. So if you could use the chat purely to signal me that you have something that you want to add or that you want to get into the queue, I would very much appreciate it. With that, I'm going to turn the meeting over to John Siegel, who is the person who has been conducting this research, or the leader of the team conducting this research. And John, we'd appreciate it if you could give us a presentation of your research and how we can help you.
Well, thank you so much, Kristen. I'm very happy to be here today, and I also want to thank Matt for taking me on as the consultant for this project in the first place. It's been a very interesting and enjoyable project. I've been going at it for a while, and I'm really pleased to have this opportunity to give. Well, I think this is the first public look at what this project is about and where it's going. So why don't I start by giving a little background on the project, and then I will come on to the particular recommendations that are mentioned in the memo that you have before you. So to understand this project, you really need to first think back to a previous project, which was the ACUS Sourcebook of Executive Agencies. That's a project that was begun, I believe, back in 2011 when I was still the Director of Research and Policy for ACUS. And it was the brainchild of then Chairman Paul Verkyle. And he said, let's make an analysis of every agency in the entire executive branch. Let's go through all of them and note all of their characteristics. So we'll note which of them have heads that serve at the pleasure of the president, and which one have heads with some tenure protection, and which one are single-headed agencies, and which one are multi-headed agencies, and which ones have independent litigation authority, and every other characteristic you could think of all the executive agencies. Let's analyze all of them. And I have to say, I was perhaps a little skeptical at first. I thought, well, we're just going to produce this big table of information. Who's going to care about that? But the project came out really well. First of all, Paul recruited this very excellent fellow, David Lewis, who was then, I believe, at Princeton. Now he's at Vanderbilt to do the project, and he was assisted by Jennifer Seelan, who I think was then a PhD student. Now she's a professor herself. And yes, in some sense, the project produced this big table of information, but they built a frame around the table. They added this narrative commentary that put the information in the table in a very interesting and useful context. And then on top of that, it turned out a lot of people were quite interested in the table. It turned out, particularly people up on Capitol Hill, find it very convenient to have this table in which they can easily look up all these different characteristics of the executive agency. So it turned out to be a very successful project. So this project, Matt approached me and said, we're going to do something similar with provisions for judicial review. We're going to go through all the provisions for judicial review in the entire United States Code and make a table of all their characteristics. You know, how much time they allow for review and what is the standard of review and where you get review and all these different characteristics. And I thought, well, how interesting. Let's do the same thing for judicial review provisions that ACUS did so successfully in analyzing the executive agencies. So that's what this project is about. And it really has two parts. You're just seeing one of the two parts. So one part of the project is this overall report, this survey of all the judicial review provisions, and which itself has two parts. There's going to be the table with all these characteristics, and then the narrative report, which I am drafting. And then from that, as you do all this analysis, you notice some things that could be improved. And so that's the part that is within the purview of this committee, is recommendations that grow out of this analysis. So what we did was first to identify all the provisions for judicial review. And when I say we, that work was really done by the staff, and I would like to take a moment to join Matt in acknowledging the tremendous contributions that the staff have made to this project. I absolutely could not have done this without the staff. As Matt mentioned, I think every attorney at ACUS was involved in the initial step of identifying the provisions for judicial review in the United States Code. So I want to thank all of them. But I would like to particularly mention, without taking away from the thanks to all of them, but first of all, Frank Massaro, who is no longer at ACUS, he's moved on, but he was the staff counsel in charge of the project initially. So he did the initial organization, I believe, of the team to identify all these judicial review provisions. And then Bobby Ochoa, who is the staff counsel today, and Jeremy Grabois, who did most of the coding work. So anyway, so going back to what we did, so under Frank's direction, the attorneys at ACUS first identified all of the provisions for judicial review in the United States Code. Turns out there are about 650 of them. And then we made up a coding schema to ask, if you were going to make a big table of all the characteristics of these provisions, what would you want in the table? And in this, we were assisted by the board of advisors of the project, and I won't mention all their names. There are too many to mention. I see some of them are here today, but I would like to thank them as well. Before we made up the coding schema, we asked the board of advisors, what do you think should be in the coding schema? So with their assistance, we decided what would be coded. So it includes information such as what is the agency involved, what type of agency action is involved, how long is provided for review, where should you seek review, is bond, do you have to post a bond, is the court required to expedite review, what relief is available, what is the standard of review, all these different characteristics of each judicial review statute. And then we went through a rather long process of actually coding them up, and I won't go into all the details, but first, several of us, we all coded, we chose 15 or 20 provisions as a test bed, and we all coded all of those provisions, and then we put our heads together and thought about what we had learned from just coding a few of them, and then we tweaked the schema, and then the staff, as I said, did this terrific work coding all of the provisions, and then there was some more tweaking and some more coding. Anyway, I won't go into all those details, but the result was we finally have the master spreadsheet, which shows all these different characteristics of all the different provisions. And then the task that fell to me was to look through all of this and see what we learned by doing that. So I did this, and I dare say I may be the only person in the world who has read every word of every provision for judicial review in the United States Code. If anybody else has read all 650 of these, I'd be interested to learn that. But as far as I know, I'm the only person who's done this. And you see all sorts of interesting things, you know. So what I'm writing now is the report that just details everything that I thought was interesting in reading all of these provisions. And as I said, that is a separate project. That's going to be done under the aegis of the Office of the Chairman. But in the course of doing all this reading, you know, I saw various things that I thought could be improved, and that's what comes within the purview of this committee. So let me talk now about what I learned. I'll mention just one thing I learned, which is not in the memo that you see before you today, but which was perhaps the first most striking thing you see when you read 650 provisions for judicial review. The first thing you notice is how many of them are redundant. How many of them say only something that would be true whether it was said or not. For instance, a great many of these provisions take the trouble to say the filing of a petition for judicial review of this action shall not by itself operate to stay the effectiveness of the action. A stay shall occur only if the court orders a stay. Well, that's very nice, but that would be true anyway. Of course, that would be true anyway, whether you said it or not. A very large number of these provisions say the findings of the agency as to facts, if supported by substantial evidence, shall be conclusive. Well, of course, that follows from Section 706 of the APA anyway. Not perhaps all the time, but when it doesn't, it's just a background provision of the common law of administrative law. So anyway, there's a whole lot in these judicial review provisions that, as far as I can tell, is redundant and would be true anyway. Is that a bad thing? I discussed this in the report. You know, it doesn't do any good, neither does it do much harm. I didn't undertake to recommend that Congress avoid everything redundant. If it makes them feel better to put in some redundant things, why not? Anyway, but that's certainly one thing you notice very frequently in looking through all these statutes. All right, coming now to the things you actually have in front of you, I also noticed, and again, this does not cover everything in the report. There are things in the report where I said, well, I've noticed this. I don't see any particular recommendation that comes out of it. So you're not going to, this will not cover everything in the report. But coming to the things where I thought, here's something where I think we might wish to recommend something. The first thing I noticed is provisions setting the time within which to seek review. Now, these are not redundant. If a particular judicial review statute did not specify a time within which to seek review, the usual fallback, the only other time limit that would usually apply, would be 6 years. 6 years is the general statute of limitations for claims against the United States. So if a statute didn't specify anything shorter, you'd usually have 6 years. Well, Congress evidently does not think that would normally be a good amount, because much more usually it provides for something like 30 or 60 or some other shorter number of days. But the thing I noticed in going through it is that there are two ways in which Congress specifies the time. One, which I call the usual way, is to say you must seek review within X days after the agency's action for some number X. And of course, if you do any civil litigation, that's the amount of time you have to file a notice of appeal. You have to file the notice of appeal no later than, or that's an alternative equivalent formulation, no later than X days, 30 or 60 days in the case of civil litigation after the entry of judgment. So everyone's very familiar with how to comply with such a statute. But then a smaller number, a minority of judicial review statutes say you must get your petition for review in prior to X days after the agency action. And that gives you 1 day fewer. So if the statute says you must file your petition for review within 30 days after the action, and the action is June 1st, then you have until July 1st. If it says you must do it prior to the 30th day after the action, well, then you'd have to get it in on June 30th. And that would be unusual. That's unexpected. This gave rise, something similar gave rise to a well-known Supreme Court case called Locke. Maybe you've heard of it, which had a lot of discussion about what to do where the statute says prior to the Xth day. And people said, well, that really means 1 day fewer. And the person who got their thing in 1 day late lost. And I found, some cases in which people got their petitions for review kicked out because they were 1 day late, where this unusual way of specifying the time was used. And so I thought we should recommend that this not be used, and perhaps even Congress should say, whenever that form is used, you have 1 day more. If it says prior to the 30th day, it's okay to do it on the 30th day. That would prevent people from getting kicked out for being 1 day late. I should mention, I also found cases where the usual formulation is used and people were still 1 day late. So maybe there's just no way of stopping people from being 1 day late. But I at least think we should not set a trap for them by using this unusual formulation. In addition, still with regard to the time for review, but a separate point within that, you also, if you say you have X days from some event, well, what is the event? What is the event that starts the time? And this is particularly an issue when the event is the issuance of a regulation. So if the statute says, if you want to challenge this regulation, you have 60 days from the day the regulation is issued, what is the day that constitutes the day the regulation is issued? I don't know about you, but certainly my intuition on this point is that the regulation is issued on the day it's published in the Federal Register. Isn't that the day the regulation is issued? Well, I actually found some cases in which someone got their petition in within 60 days of the day the regulation was published in the Federal Register, and the agency said, oh, no, you're out of time. Because yes, that's the date we published it in the Federal Register, and yes, you were within 60 days of that date, but we issued the regulation on an earlier date. We issued it internally. The public couldn't have known this. No one knew on the day we issued it that it had been issued. But if you looked carefully in our Federal Register notice, we specified that it was issued on this earlier date, and that's the date that started your time running. No court, as far as I can tell, has accepted this argument, but it seems to me to be quite an unworthy argument, and I think it would be best if the statutes at least clearly specified what is the date that starts the time running when the running is from the issuance of a regulation, and I would say it would be best if that date were the date of publication in the Federal Register. So that's recommendations 1 and 2. Number 3, jurisdiction. When you look at these judicial review statutes, a great many of them take the trouble after saying you seek review by filing a petition for review in Court X. A lot of them then take the trouble to say, and Court X shall have jurisdiction to consider the case that results. But some of them don't. Some of them just say you start by filing a petition for review in Court X, but they don't say that Court X will have jurisdiction. Now, is that a problem? Well, if Court X is a district court, it's certainly not a problem because there would be ordinary federal question jurisdiction under Section 1331 because all of these cases arise under federal law. But what if Court X is a court of appeals? Courts of appeals do not usually have original jurisdiction. And if a statute does not say that they shall have jurisdiction to consider the case that results when you file a petition for review directly in a court of appeals, strictly speaking, you would have to say they shouldn't have it because, of course, federal courts have limited jurisdiction and they're not supposed to have jurisdiction unless it is both constitutional and given to them by statute. Now, I can't say I've actually found a case where this is a problem. I mean, I have in fact seen cases where the statute says nothing about jurisdiction and people went straight to a court of appeals, and the court of appeals, I presume, didn't notice the problem, or if it did, just said to itself, well, of course, when Congress says you file the petition for review in this court, implicitly that means we have jurisdiction to hear it. So, I wouldn't recommend doing anything about this if this were the only thing involved, but I have a couple of these where I'm saying if Congress is going to pass a statute dealing with all these issues, it might as well put in one to clear this up and say when we say you seek review by filing a petition for review in Court X will always have jurisdiction to consider the case created by that petition for review. As I say, I wouldn't recommend that by itself because there's no real problem. But as we all become more textualist, as the courts become more particular about actually reading the text of statutes, let's head off that problem before it starts. In a similar vein, number 4, what is the style of the document that initiates the review? There are different styles mentioned in the different judicial review statutes. Some of them say you do it by filing a petition for review. Some of them say you file a notice of appeal. Those are the two main forms used. Others say something like you just seek review. They don't say exactly what you're supposed to file. I even found a couple that say you seek review by filing a bill in equity, which I must say I was surprised to learn because as far as I know, bills in equity were abolished in the federal system in 1938 when the Federal Rules of Civil Procedure became effective and merged law with equity. And as far as I know, it is not possible to file a bill in equity in federal court today, and yet there are still a couple of statutes that tell you to do that. Most of them don't have cases under them. But in any event, these different forms of the petition or the document you're supposed to file to seek review give rise to the question, what if the statute says file a petition for review and someone files a notice of appeal, or vice versa, just to deal with the two main forms that the statutes provide. And again, this is not a particular problem in almost all the cases. I find the courts just deal with this. They just say treating the petitioner's petition as a notice of appeal or treating the notice of appeal as a petition for review. We move forward from there. I found very few cases, not zero, but a very few cases where the court refused to treat one as the other. Again, who could possibly care what the style of the document is? Plainly, a petition for review should be treated as a notice of appeal or vice versa where necessary. If you saw the comment that Professor Duffy sent in earlier today, he said none of them should be called notice of appeal. They should all be called petition for review because notice of appeal suggests an appellate proceeding. And these are really original proceedings. I agree with him. So we could, all of these recommendations are, of course, open to tweaking by the committee. If the committee would prefer to say, it should always say petition for review, that's fine with me. Point 5, what about the content of this document? Almost all of the statutes that say, initiate review by filing whatever it is they tell you to file, almost all of them say nothing about what should be in that document. So they just say file a petition for review or file a notice of appeal. And in my opinion, that is a good thing because that allows the rules of civil procedure or the rules of appellate procedure to specify what should be in the document. And the rules of appellate procedure, the federal rules of appellate procedure, specify the content of a petition for review. And they're very minimal. So again, those of you who are involved in ordinary civil litigation know that when you file a notice of appeal, the notice of appeal itself is typically just one sentence. It just says, please note that I appeal this judgment, and you say what judgment you're appealing. You don't say in the notice of appeal why, for example, you're appealing or what relief you want. So similarly, the rules of appellate procedure say when you file a petition for review, you just specify the agency action of which you're seeking review. You don't have to say why the action is wrong or what relief you want. There are a couple of statutes, most notably the Hobbs Act, which covers a group of agencies, and the main statute for review covering the FCC, which say you are required to say why you are seeking review, and I believe in one case what relief you want. Fortunately, those, I think, and there are judicial holdings to this effect, were superseded by the introduction of the Federal Rules of Appellate Procedure. So I don't think any of the two statutes I've identified that require more are effective today, although people in the FCC community seem to think that they are still required to say why they're seeking review, what was wrong with the action of which they're seeking review. But the superior practice, I think, and this is, it is because we believe this to be superior that the rules are what they are, is not to require in the note of appeal or the petition for review a statement of the reasons. It's often too early at the time someone's filing their notice of appeal or petition for review. They don't necessarily know already exactly what grounds they wish to raise. So it's better not to require it at that stage. That can be explained at a later stage of the proceeding. Let's see what's next. Oh, the race to the courthouse. This one was interesting, and this comes back to one of ACUS's most successful previous recommendations, the recommendation 80-5, the race to the courthouse recommendation. So prior to recommendation 80-5, if multiple petitions for review of a single agency action were filed in different courts, precedence was to be given to whichever was filed first, which led to some quite undignified and rather silly investigations into which petition for review was filed, a mere matter of seconds or minutes before another one. So in recommendation 80-5, ACUS said, where multiple petitions are filed, why don't we have a lottery system to determine which of them is the one that will go forward? And Congress adopted that. But it happens that the exact form of words that Congress used makes the lottery apply only if the petitions are received at the agency directly from the petitioners. And as I discovered in my research, many statutes say you file your petition and then the agency gets a copy of the petition from the clerk of the court, not necessarily directly from the petitioner. And technically, if you read the statute that solved the race to the courthouse problem, it says, well, that doesn't count. It's not enough that the agency got a copy of the petition from the clerk. It has to come straight from the petitioner. And guess what? Some cases have read that and said, well, we're all textualists these days. That's what the statute says. The end. So the ACUS solution to the race to the courthouse problem is not working in that kind of case. And I recommend that we tweak it a little so that it will cover that case, because there's no reason why it should matter whether the agency gets the petition from the petitioner or from the court. And that, in fact, is also the topic of the final recommendation. How does the agency get a copy of the document that initiates review? There are different ways the statutes handle this. Many require the petitioner to send the agency a copy. Others require the clerk of the court to do it. Some of those that require the petitioner to do it say the petitioner must file it on the agency or serve it on the agency simultaneously with filing it. And again, I can't find a case that ever said this is a problem, but it did occur to me to wonder, well, what if you filed your petition for review and sent the agency a copy the next day? Would the agency say, oh ho, you didn't serve it on us simultaneously? So I suggested that it should be enough that you filed it at the agency with reasonable promptness. And then Professor Duffy, again, in his useful comments, said it would be better to be more precise than that, which now that he's mentioned it, I think that's right. So maybe that should be tweaked as well. Anyway, so those are the 7 things that you have before you as matters where I thought some improvement could be made based on just reading through all these statutes. I have actually, as is mentioned in the memo from Bobby, I have a few others percolating in the report that might come before you separately. They're perhaps too big a topic to fit into this proposal, but you'll probably hear about them at some later date. So that's the background, and that's a quick look at each of the recommendations in today's memo.
Thank you very much, John. I really appreciate it. So I can think of a couple of ways that we could proceed here. And John, I want to do what is most helpful for you, because at this point in time, we're not formally considering a draft recommendation. We've sort of got drafts of what might eventually be draft recommendations. We can go through them one by one, or we can take them somewhat globally in terms of suggestions. Again, I'm going to remind people that if you want to get into the queue, I would appreciate it if you could signal me in the chat. And I have also posted in the chat a link to the ACOS webpage where you can find the documents, both the memo that John just described, as well as Professor Duffy's comments that he sent earlier today. I've also got a comment that was submitted by Paul Kaminer, which I'll talk about in a minute, but we don't have anybody in the queue at this point in time. So I guess we'll go with either approach. If somebody has a particular comment with respect to a general recommendation, then that would be great. Alan Morrison, please.
Can I just say one word? Can I just say one word?
Yes, please, John, go ahead.
Yes. I'm sorry, Kristen reminds me that Alan, we're going to come to you in just one. Well, go ahead. Kristen reminds me. I'm sorry. I meant to say something along the lines of what Kristen was just saying. What can be helpful in this session? I look on this as sort of a brainstorming session. You have several particular recommendations that came out of my research before you. But I'm happy to receive any suggestions for what else I should be looking at, how these could be tweaked, what other things along these lines or similar lines, or, what else you might particularly want to know about all these judicial review statutes that are going to be mentioned in the report. I'm interested in hearing your ideas about any of these. So as I say, I think this is just a general brainstorming session that can help form the proposed recommendation that will probably come before you sometime next year.
Okay, and I've got a queue at this point of Alan Morrison and then Ron Levin. Before we turn to Alan, I will make one observation. We do have the recommendations from, or the suggestions from John Duffy replying to John on the web page. I suppose, when it comes down to it, if you want to take a look at those and you have any suggestions that relate to John Duffy's suggestions as well, to the extent this is just a brainstorming session, we would welcome those too. And we've added Michael Hertz to the queue. So let's start with Alan and then we'll turn to Ron and Michael. Alan, go ahead, please.
Thank you. I looked at John's memo quickly and I might have some thoughts on it, but I don't think this is really the time to go into them. So I have three questions about really having to do with scope. Should we be undertaking the question in this study, and I don't say yes or no, as to whether the district court or the Court of Appeals is the right place for these cases to be? Some agencies like the FDA in particular, some of its cases go to one court, some to the other. And so that's just a question about whether we should do that. Second, when John got talking about 6-year statutes of limitations, I wondered whether, and this again is a scope question, we should ask ourselves, does that apply if a company is sued, for example, for violating a rule, and the company argues that the rule is unlawful? Can they defend more than 6 years after the rule was issued? And the third question is, I believe there was a case in the Supreme Court last year or year before about races to the district courthouse, and what should be done about those if they are in fact races. That may get too close to the nationwide injunction question, but as long as we're talking about possible scope, I thought I would raise that as well. That's all I've got. Thanks.
And I want to give John a chance to respond. Before I do, let me just make one observation that maybe I should have made already. If we end up having time, Matt had flagged for me 3 issues that are somewhat tangential to this project, but not necessarily of this project, that we might take up as future projects, one of which, Alan, is the one that you suggest, being the choice of court between federal district or federal court of appeals. The other 2 being issue exhaustion and judicial review during enforcement proceedings. So, I'll flag those for you all with the idea that hopefully we may get a chance to discuss whether they would be projects we might want to undertake in the future. But John, let me give you a chance to reply to what Alan had to say before we turn to Ron Levin.
Well, thank you. Yes, that first thing you mentioned, Alan, whether review should be sought in a district court or a court of appeals, is in my report. And I think I have a recommendation that is along the lines, Congress should consider putting things directly in a court of appeals, because going to a district court is usually a waste of time in reviewing in an administrative review case. I believe it was Matt and Bobby who severed that out and decided it would not be included in what the committee has before it today. And I think the rationale, which is I would agree with, is that the things you have before you today are what Matt characterized as housekeeping things, which I think put all these things together, they add up to about one good ACUS recommendation, even though any one of them might be not important enough. But the question, should review begin in a court of appeals or a district court? That's perhaps a bigger topic. And similarly, your question of to what extent can review be sought in enforcement proceedings, those are perhaps bigger topics that would perhaps be a good subject of a recommendation by themselves, rather than putting them in this. So yes, I agree they're good topics, and the first one is definitely already in the report, but I think that's why they're not before you today.
John, if I can just interrupt real quickly, Kristen, could you just say a word about, on the question of choice of forum, can you say just a word about the earlier ACUS recommendation, the one that I think was based on Frank Goodman's report in the mid-70s? Because this is not new territory for ACUS. We do have a recommendation on choice of forum, which is not to say that it shouldn't be revisited, and which is not to say that we shouldn't undertake a very extensive empirical study on this question.
I mean, the basic point is that judicial review is already in the nature of an appellate proceeding. The reason cases normally start in district court in ordinary civil litigation is that someone needs to compile the factual record, and that is the role of the district court. In a proceeding for judicial review of agency action, there's already a record compiled at the agency level, and whatever court the case starts in is going to be reviewing that record. So to have the district court review a record followed by an appeal to a court of appeals, which will review the same record, is typically not productive. And the Supreme Court has expressly said, that typically is not a good use of time. Now, there are some matters like Social Security disability cases where there are just so many of them that I think they would overwhelm the courts of appeals, and perhaps that's why those start in district court. And there are certain other areas where there's some other reason to start in district court. But in general, you would think judicial review of agency action could start in the court of appeals. And Matt, you have to forgive me. I'm not sure I know exactly which prior recommendation you're referring to now. But is that what the prior recommendation says?
I think that's roughly in accord with the prior recommendation. I think your perspective is in accord with the recommendation. It did acknowledge, though, that there are cases, mass volume type situations like Social Security, where it still may be appropriate to send the cases to the federal district court in the first instance. So that's all I was referring to. But I just want to point out that, and we can circulate it afterwards, that ACUS does have a recommendation called choice of forum, which was based on a report by, I believe, Frank Goodman in the mid-70s.
So I will make the observation that the 1970s is a long time ago at this point in time. So it might be worth undertaking a new study, and consider separately the choice of forum question and whether a new recommendation is worth exploring. Things have changed a lot since the 1970s, for that matter. But in any event, I think next in the queue was Ron Levin.
Yes. So this is an extremely general question. Am I correct that the coders recorded only what the United States Code has on its face, as opposed to meanings that courts have read into the statute, maybe aggressively read into the statute, And if that is so, as I imagine it is there a way for the descriptive part of the process to take account of those glosses? The example that came to mind is that in some statutes provide for people to seek review of orders, and orders is construed to mean rules. That is not a meaning that the average reader would expect, but it's highly important to people in that, and so you would want to have some way for people to know that. Now, the normative recommendation can say that's a poor way to do business and it should be changed, but that doesn't fully answer the descriptive part. And there probably are other examples that don't come to my mind that would raise the same type of question.
Shall I just go ahead and answer that, Kristen?
Please, I'm done.
Yes, please, go ahead, John.
Yes, first of all, your main observation is correct. The coding just looked at what characteristics could be discerned by reading the text of the statutory provisions on their face, and did not undertake to discern, discover, research what gloss had been put on those words by judicial construction. In my report, I am endeavoring in some places in my report to undertake to do that. I can't say I've done it at every point in the report, but I am generally undertaking to do more looking into. Again, I should mention, with the assistance of the staff, I've given some research questions to the staff to look into at this stage, but I am attempting, with their assistance, to look further behind the language in the statutes and see what gloss has been put on it. But as you can imagine, that adds, a whole extra level of complexity to the research. I mean, it's already quite a task to look through the text of 650 provisions, to look through the text and investigate all the judicial glosses that have been put on the text is even more of a task. So yes, I am trying to do it, but I can't say I'm undertaking to do it as to every point in the report.
Okay, next up in the queue, we have Michael Hertz. Please go ahead, Michael.
Okay, hi everyone. So I had two questions sort of following along the lines of Alan's, initially going to scope. The other issue besides district versus court of appeals is provisions that limit review to the DC circuit. And so A, I'm wondering, was that one of the things you tabulated? And B, is it something, can we say anything about, either in this or in the spun off project, when and why it might be appropriate to limit it to a particular court of appeals? The second thing is just about the time limits. It's a recurring ACUS issue about how much to bite off. And the lock problem is real and cute and nice. But the real question is, what's the right amount of time during which, that people should have? Is 30, 60, 90, 120 days, a year? And so I'm wondering if in the report you at least, there are two things. One is, can you kind of common law style synthesize the provisions and come up with some conclusions about when it's 30 or when it's 60 or when it's more? And the second is just a normative one about whether we ought to at least think about whether we can say anything useful about the appropriate length of time that one should have for filing a petition for review.
I think those are, again, excellent questions. I do have a section about when review is geographically limited. Most provisions are of the form you can seek review either in your local court, so wherever you reside, or if you're a business, wherever your main office is located, or in the District of Columbia. And that seems to me generally appropriate, in as much as the government has attorneys everywhere and can defend everywhere with roughly equal convenience, but that might not be so true for the petitioner. Although, I would say these days it is more true that the petitioner could sue in DC just about as easily as wherever the petitioner is. That is at least more true today than it was when many of these statutes were drafted. Now that we're all so connected. I mean, here we all are having this meeting, even though who knows where we all physically are. I assume we're spread about throughout the country, and yet we're having this meeting, and it's no problem. So the fairness to the petitioner of saying you can sue in your local court is perhaps less important than it used to be. And if you look at those situations where review must be brought in D.C. or in sometimes in some other specified place other than D.C., that's unusual, but it does happen. Presumably Congress is trying to get some uniformity. They don't want things to percolate. They don't want people to try to seek a little strategic edge by taking advantage of better precedent in one circuit than another. So that I think would have to be balanced. Do you want to take away the petitioner's convenience, but not give them this opportunity to seek a strategic edge? So anyway, so yes, I do discuss that question. The other question you raised, again, a very good question. You point out, perhaps with some justice, that the timing question I focused on is the somewhat cute question. I think that's the word you used of, exactly how many days you have. Should you have 29 days or 30 days? Whereas isn't the bigger question, what is the right length? Should you have 10, 30, 60 days? And, I'm happy to explore that question more. I don't think I'll have time to do it in the first draft of the report because that's due pretty soon. But in the final report, I would be happy to look into that some more. I mean, so far I can't say I've discovered a great deal of rhyme or reason into what goes into 30 days versus 60 days or even versus 10 days. I mean, yes, you can kind of see in the cases where only 10 days is allowed, it's about things that are more urgent. But what gets 30 days versus what gets 60, it's not easy to discern any particularly forceful pattern as to that. But I'm happy to think about that some more.
Okay, I will point out for convenience that Bobby has posted a link to ACUS recommendation 5-3 regarding choice of forum into the chat area. So if you're interested in going and looking at that, the link is available to you. Andy Bolmer is next in the queue.
Thanks, Kristen. So thanks to everybody, and John in particular. This is all terrific. And thanks to John Duffy for his comments. I had one principal question, and it bears on some smaller questions. But maybe it's just wise for me to get out my couple points like Alan Morrison and Ron Levin have done, and then there might be answers to some of them, and others might deserve a little more comment. So the most important question on my mind is whether this general review statute would explicitly override all currently existing statutes. Or, so would it say notwithstanding any other provision of laws and therefore supersede the current judicial review provisions in organic statutes principally? Or would it do the opposite? Would it say these provisions apply only if there's no equivalent or comparable provision for a particular agency? And this is going to matter for a reason I come to. So here are the couple smaller points. First, if I could return briefly to the District Court versus Court of Appeals point, and maybe nothing more needs to be said. We talked about it, but here's what I wanted to mention so that you have it in mind. My main knowledge is in the federal securities law area. So I know the federal securities laws particularly well, and I don't know much about other judicial review statutes. In the federal securities laws, the two main laws, as most of you already know, are the Securities Act of 33 and the Securities Exchange Act of 34. They have judicial review statutes that are different. Both of them create traps. So you see when somebody wants to challenge SEC action, typically a rule, you'll see a protective, a protective filing in either the Court of Appeals or the district court because people don't know. So the 34 Act is very peculiar. It's got one provision on challenges to orders and a different provision on challenges to rules, but only rules adopted under particular sections of the Securities and Exchange Act. So that's what causes this complexity. The 33 Act, the Securities Act, has only one provision on judicial review, and it refers to orders. I know for a fact that the DC Circuit has taken a direct challenge to a rule without any discussion of whether it had the power to do that. So maybe there's some case under the 33 Act where the DC Circuit says we're construing order to mean rule. I mean, Ron Levin mentioned, I think somebody mentioned the possibility that there's a case like that. And for all I know there is, I don't happen to know for sure. But if you just look at the language of the statute, and certainly when you compare the 33 Act to the 34 Act, there's a big difference between orders and rules. So you can see this is the main reason why I'm asking about whether the general review statute would supersede or supplement, or how would it fit with the current statutes, because it's sort of a pain in the neck for people who are trying to proceed under the federal securities laws. So that was my second point, which is getting back to the district court versus Court of Appeals point. My third point is on the statute of limitations. I agree with Alan Morrison, and I don't know if judicial decisions have clarified this, but John Duffy's paper suggests that 2401 has been read to be a statute of repose by some courts. I'll take him on faith. I don't know that. But strikes me that you cannot disable a defendant from raising the invalidity of a statute, the invalidity of a rule as a defense. Now, I don't know, maybe there's a bunch of law on that, I just don't know, and a lot of you might know it. That'd be great, tell me. But there are securities regulations that authorize certain kinds of behavior that can be challenged as a violation, and yet it's not at all clear those SEC regulations are valid. But that doesn't mean that a particular defendant ever challenged it during the 30-day period for challenging rules, because most of the time, people who are sued by the SEC for a violation don't know they're going to be sued as a defendant, and therefore they're not challenging liability or enforcement related SEC rules. So I just think a lot more thought needs to be given to the statute of limitations problem. And by the way, I just want to add, I don't understand why 2401 applies to a petition for review in a court of appeals, because 2401 refers to any civil action. So I wouldn't have defined a petition for review in a court of appeals as a civil action, but maybe that's what the courts have done. And so I just think there needs to be either more discussion, or I need to be filled in maybe on well-established law. Here's my final point. It's a point John Duffy raised and John Siegel mentioned quickly, and that is on these statutes that have the clerk of the court serve a petition for review, which, by the way, the securities laws statutes do. So I understand the little hiccup in this lottery system that you all have been discussing. I get that. but John's proposed a system through which DOJ has got an obligation. You have to serve DOJ, and then DOJ serves the agency. Well, again, I only have an SEC perspective on this, but DOJ does not have litigating authority for the SEC except at the Supreme Court. And it just strikes me that the better rule here on service, if we're going to try to write a general rule, is the person challenging the agency action who is in the nature of a plaintiff or the petitioner in a court of appeals. Like the standard rule in litigation is, if you file a piece of paper in court, you gotta serve it. And I don't know why we would vary from that. So I would recommend the general default rule ought to be the challenger to the agency action should serve the agency, not the Department of Justice, not the clerk of the court, just should be the petitioner or the plaintiff. So anyway, those are a couple of my thoughts, and happy to discuss any of them more.
So John, I want to give you a chance to respond, but before I do that, I do want to, just echoing some of what Andy was saying, I will point out too, so my area of specialty is tax, of course, and the Internal Revenue Code has very extensive judicial review provisions centering around particularly deficiency actions in the tax court. With a whole complete regime that's set up. I guess one of the questions that I have is, to the extent that, and I think this echoes some of what Andy was saying, or at least what I understood Andy to be saying, with some of these recommendations, to the extent that they're talking about a general statute, or if we're talking about some sort of general legislation that Congress adopts to try to fix some of these problems as opposed to going piecemeal statute by statute, how do you reconcile that with existing statutes that have, either very extensive judicial review provisions or simply just alternative judicial review provisions that would contradict a general statute? Because, to the extent that normally we think of the specific statute trumping the general one. So I'm curious as to how logistically that might work. Go ahead, John.
Well, thanks. To take that question, how would it work? Well, obviously, there are different ways it could work depending on how the committee chose to write its recommendation and ultimately how Congress chose to do something, if Congress chose to do anything. So, for example, on the question, what is the length of time within which to seek review, I actually, in my current draft report, have three sort of tiered recommendations. The simplest recommendation is simply Congress should avoid setting the time by saying you must do it prior to the Xth day. Congress should avoid using the unusual way of doing it because that sets a trap. The second tier would be to say Congress should pass one statute, Congress should do some research, or they should just look in our table, which will have this, identify all the current statutes that use the less desirable form and pass one statute amending all of them and then not do it again. And then the last, most aggressive, perhaps, recommendation is to say Congress should pass a general statute, and this now gets most particularly to the question that you and Andy are asking. The general statute would say wherever some other statute says you must file your petition for review prior to the nth day after the action, it is sufficient if you file it on the nth day after the action. So if Congress did it that way, then that would supersede what the other statute says. It would give you one more day than the other statute gives you. Now, obviously, before undertaking to do something like that, you would need to carefully think about whether that could screw something up. So that's why I put in these tiered recommendations, because of course it's much gentler and easier and less likely to cause unexpected problems simply to say, we recommend that you not use this form of words, but instead prefer this form of words as you write statutes. That is less likely to screw something up than to say, pass a statute which reaches into every other statute and tweaks it just a little in a way that, as far as we can imagine, couldn't possibly cause any trouble, but who knows if we're being sufficiently imaginative. So yes, I see that potential pitfall that could happen if you pass a general statute. I think I feel pretty comfortable saying giving people one more day is not going to cause any great harm, but we might not be equally confident as to every provision that might be in this general statute. I mean, again, I think saying whenever another statute says, seek review by filing a petition for review in this court, that court shall then have jurisdiction. It is very, very hard for me to imagine what problem that might cause. It seems to me that could only solve a problem, not create a problem. But if what you're saying is, whenever we recommend something general like that would operate on top of every other statute, we should certainly be careful. I certainly agree with that. And then just mentioning quickly Andy's other 2 points, I have read those SEC statutes because I've read all of them, but I can't say that I noticed the particular point, Andy, that you were raising about it, orders versus rules. So I will go back and look at those again and consider that point. And then the statute of repose thing, I just saw that this morning from John Duffy. I'm going to have to think about that one. Oh, and who should serve the petition? I guess what I would just say about that is, Federal Rule 4, I believe, does contain already an existing provision saying whenever you're suing the United States, doesn't it say something like, if you're not sure whom to sue, you can serve the Attorney General or something like that, and that is sufficient. I'm getting it out as we speak, so I'll correct myself in a minute if I'm wrong. But the point is, it's not always quite so clear exactly how service is to be made because the United States is a big and complicated organization. And so I think the point of saying the court should have the duty to serve is just that if there's any difficulty in making the service properly, we don't want people to lose their right to review because of the complexity of figuring out who to serve. So that's just what I would add about that.
Okay, even though we've been meeting for a little over an hour, because our meeting is only scheduled to last an hour and a half, I'm not going to take a break. I'm just going to keep us moving forward. Next in the queue is Boris Burstein.
Hi, good afternoon. First of all, thank you, John, for undertaking this and for the obvious investment you've made. I think it's a great public service. My one question, which is I think a very discreet one, is to the extent that you will you will address the more assertive approach of a general statute. And I saw in the staff memo a couple of instances when specific language for the general statute is being proposed. Would it be your plan to include, at least for the committee's consideration, a form of the general statute? And I will say my bias is to do that, particularly when you're addressing issues that I would maybe say, instead of cute, I would just say are more in the nature of technical assistance, where you are unambiguously resolving a problem as opposed to necessarily addressing an issue on which some may consider a problem and others may consider a benefit. And I think I'm concerned that when we say Congress should do this and describe it in narrative form on the subject that is so technical, we're missing an opportunity, for what appears to be the world's leading reader of judicial review provisions to actually anticipate some of the problems that might arise in drafting, since you really are the specialist. So I would urge you, to the extent possible, to actually propose a form of statute.
I mean, am I on? Yes. I'm happy to do that. I mean, today is just a brainstorming session. When we get further into the stage of actually, approaching an actual committee recommendation, yes, I think that's a good idea to have some actual language. I mean, I did that with regard to the race to the courthouse issue. I haven't done it yet on this issue, but yes, and before doing it, I think I might want to perhaps get in touch with someone over at Ledge Council at one of the houses of Congress, to see if they have any suggestions. Someone with a lot of experience in actual statutory drafting. Because as I say, if you're going to draft a general statute, you want to be careful as you're trying to fix something, not to break something else. But yes, I think that's a good idea.
Okay, two more things. So just to read into the record, Allison Ziva has placed a comment in the chat that service under Rule 4 is on the agency, the U.S. Attorney, and the Attorney General. I also want to read into the record a comment that was submitted by email from Paul Kaminer, but that is not posted on the web page, observing that an issue that might be relevant is that some statutes don't provide for any judicial review, but the judicially created default rule is to file in the district court, even though it's de novo review of the agency record. But some litigants unwittingly first file for review in the Court of Appeals. So maybe Congress should make clear in an omnibus statute that judicial review, even though not provided nor precluded, and unless otherwise specified, is in the district court, along with other points made in the report, like the review and so on. Which at least does seem also to be getting back to this question of choice of forum to some extent. I'm not sure with respect to Paul's comment whether it's really a choice of forum question or more of a housekeeping question. It seems to me to be a little bit in the middle of the two. John, I don't know if you want to make any comments with respect to either or respond to either of those comments, or if we want to move on briefly to talking about other potential future projects.
Well, I'll just say briefly, Section 703 of the APA says that when you seek review, you do it using the special statutory review provision for the procedure, for the action in question, or in the absence or inadequacy thereof, any applicable form of legal action. So, that means where one of these provisions exists and says where to seek review, that's what you do. In the circumstance Paul describes, where the provision doesn't say anything, then you have to sue in district court. You couldn't go straight to a court of appeals if there's no statutory provision specifically telling you to, because courts of appeals don't, as a default, have original jurisdiction. And while I'm mentioning 703, I meant to say in response to Andy, 703 also does say, except to the extent that prior, adequate, and exclusive provision is made for review, you can seek review in the context of an enforcement proceeding. That's not the exact language, but something like that. So unless a statute says you have some prior exclusive opportunity to seek review, the normal principle is you can do it in the context of an enforcement proceeding, although I'd have to consider how that interacts with a 6-year statute of limitations.
Okay, next in the queue is Matt. Please go ahead, Matt.
I just wanted to say, apropos of the point that Boris made, is that when I envision a recommendation project to be approved by the council, I would think that the committee's charge would actually be to draft a statute, an annotated statute, presumably, that could be presented to Congress for adoption, rather than having general language along the lines Boris was talking about, that Congress should do this, that, and the other thing. There are times when ACUS does not do that for one reason or another. But I think in this context, that would be the most advisable practice, and that's at least what I have in mind with respect to an actual recommendation project of a housekeeping sort.
Thank you, Matt. In the 15 minutes that we have left, I do want to return to the 3 other issues that Matt had at least flagged for me as possible future projects and maybe try to get the temperature of the committee with respect to interest or viability with respect to these projects. One concern to exhaustion, which my understanding is ACUS has addressed in the past, but there always seems to be plenty to talk about. Another is one we've mentioned already, this or forum between the Court of Appeals or the Federal District Court. My understanding is that we would, separate apart from John has already, we would need more extensive additional study with respect to that, although perhaps I have misunderstood in that regard. And then third is judicial review during enforcement proceedings. Again, I understand there has been some past work by ACUS on this topic, but that doesn't mean there isn't room to do another additional study. John, let me see if you have any thoughts that you want to share initially regarding these three possible future projects. And then I'll open it up to the committee to see if anybody has any thoughts, either pro or con, as to whether we ought to suggest pursuing those.
Well, I'll just mention that those other topics are going to be covered in the report, and as to some of them, I have something like a recommendation, although perhaps not as specific as some of the ones that are before the committee today. And as I said, I think Matt and Bobby chose to sever those out, and I'm not disagreeing. I think that was a good judgment, because those are sort of bigger topics. They're thematically different from most of the things that the committee has before it today. But yes, those are going to be discussed in the report. And one other thing I'll just mention, the topic I've been saving for last in my own drafting, is what these judicial review provisions say about the all-important standard of review. Because there's also all kinds of interesting variations that these statutes make on the standard of review. And one interesting thing I'm noting as I'm finishing this up is that sometimes Congress apparently attempts to make a variation in the standard of review, but the courts just say, no, we're just doing what we usually do. So that's just an interesting feature that I've noted. Anyway, so I'm going to have something to say about that, although I'm not yet sure what or if it will take the form of a recommendation or just here's what I've observed.
Well, let me ask this, Matt, since you're here, I mean, I understand as John suggests that, his report talks about these a little bit, but that, you all severed them off because they are different in scope and in different in type from, the rest of the recommendations that we've been talking about thus far. What do you, when in severing them off, what more do you think needs to be done in terms of a potential future project that we ought to contemplate, pro or con?
Well, I think on the choice of forum thing, and I'm supportive tentatively of all of these projects. On the choice of forum front, I think we would want to undertake to pick up on a suggestion that Steph Tatham, who's on the line, made a number of years ago while she was on the ACUS staff, but a very far-ranging empirical study to see where cases are actually being filed and in what volume in various places. I would think we would probably, for that, would want to put some kind of research team together and to draw on some, especially civil procedure scholars who are very, very adept at dealing with federal court data. So I guess what my thought on the choice of forum is that I'm not sure what more I have a feeling that the committee that ACUS would come out much the same place as it did in 1975, and that the sort of considerations, my view, have not changed that much, but I think it would be very valuable to get a handle on this issue at a very empirical and quantitative level. So that's sort of my thought on that one, but I'm certainly supportive of a study on that. With respect to issue exhaustion, I'd like to sort of know a little bit more about what we're talking about here. Are we talking about issue exhaustion in rulemaking proceedings, which ACUS touched upon, is twice touched upon? Are we talking about issue exhaustion arising from agency adjudications? That issue is now before the Supreme Court in a Social Security case. There are a lot of doctrinal issues associated with that. So I would like to just hear more about that. And I guess we have to see what John's report or source book looks like before assessing whether it's adequate to support a recommendation project on one of these three subjects. Is that responsive?
Sure. I mean, John, do you want to respond to what Matt had to say, particularly, I guess, with respect to issue exhaustion and perhaps also judicial review during enforcement proceedings? Of course, we haven't seen your report, so we don't know what it's going to say. So I'll admit it's a little bit hard to envision of where we might take it from there.
Well, let me just, first of all, just so we're all on the same page, when I use the phrase issue exhaustion, what I at least mean by that is the question, can someone seek judicial review of an agency action based on a rationale that was not raised at the agency level, or does it have to have been raised at the agency level, and does the petitioner have to have raised it at the agency level? You know, there's a fair bit of background common law of administrative law on that topic, and the Supreme Court considered it fairly recently, and they said, well, the more the administrative action is like an ordinary civil proceeding, so the more the whole thing is like civil litigation, the more it makes sense to say that you have to have raised something in the initial decision level before you can raise it at the appellate level. So that means it makes more sense in adjudication than it does in rulemaking, but it depends on the kind of adjudication. So the Supreme Court case was about Social Security, and they said, you know, that is sufficient. I think it was Social Security. Anyway, they said that is sufficiently unlike traditional litigation because it's a non-adversarial proceeding that they didn't want to apply issue exhaustion. So anyway, I just described that, and then all I think I had my recommendation say was Congress should follow the prior ACUS recommendation, which wasn't that long ago. Jeff Lubbers was the consultant. Congress should follow this prior recommendation. So I didn't really suggest anything new. And then I'm sorry, what was the other topic? So that was
the other one on my list is judicial review during enforcement proceedings. And that's all I have.
I have to say, I'm not even sure I have that in the report. I've got, so I mean, I know I've got issue exhaustion, but the judicial review in the context of enforcement, that's a little separate. Well,
it may be that my notes are incomplete and that was just a separate possible project to talk about. Matt, do you have any additional thoughts on that one?
I don't.
I may just be blanking.
Bobby, do you know what issue? You know, I'll just be very candid here with respect to this judicial review and enforcement. I'm not sure exactly what we're talking about now. Do you know, Bobby? Or Reeve?
Oh no, I'm sorry. I do have it. I'm sorry. I was just blanking for a moment. Okay. So again, as I said, 703 says that except to the extent that there's a prior adequate and exclusive opportunity to seek review is available in enforcement. So I've currently got one thing that I haven't mentioned, but that my original charge from Matt and ACUS was it was to include a checklist for Congress at the end. So I've currently got on the checklist, you know, remember that is usually available. There are some judicial review provisions that specifically say review is not available in enforcement, and typically those are provisions which say, you know, here's your opportunity to seek review. If you don't like what the agency does, if the agency imposes some fine on you or other, you know, here's your opportunity to seek review, and then if you don't do it within that period, and the agency later brings a civil action against you saying, all right, now cough up the money, you can't at that time challenge the validity of the penalty that was imposed on you. You had to do it earlier. So there are situations where Congress has prohibited review in the context of enforcement. But unless Congress does that, 703 says it usually is available.
Well, I will simply make the observation, I think all of these topics sound very interesting. Even I don't necessarily consider it problematic just because ACUS has had something to say in the past that we can't, that doesn't necessarily seem to me to be prohibitive of us going ahead and pursuing another project on a particular topic. I will admit personally, I think the choice of court topic, the idea of conducting a new empirical study that looks at, where things are being filed and under what conditions and so on and so forth. To me, that sounds particularly interesting. I guess one question I might have is as fascinating as I think the study would be, if our assumption and best guess is that it would lead us to a similar conclusion from recommendation 75-3, then if we don't think we're going to change anything from what we did 40 years ago, then at that, or 45 years ago at this point, then does that mean we shouldn't do the study? I've only been on ACUS for 3 years, so consequently, I'm not entirely sure what policy or practice might be in that regard.
No, we could, no, I mean, first of all, Kristen, I'm in agreement with everything you've said here. And we could very well undertake a study that's not tailored to a particular and a potential recommendation. I mean, we could certainly do that. My only point, sort of with respect to doing an empirical study, I mean, one important question to me would be, what sort of volume are we seeing in district courts with respect to challenges to administrative action that should be, contemplated here? And I think that one thing that I would certainly recommend that ACUS do is that on this question of choice of forum, that we consult with the Judicial Conference of the United States.
That seems very sensible. In the 4 minutes that we have left, does anybody else have any thoughts regarding any of these proposals for possible future projects?
Kristen, do you think it's, I don't know if you want to sort of do an informal poll of the committee. I mean, do you think the sentiment here is that it would be advisable for ACUS to do what we've called, undertake what we've called sort of a housekeeping project? It wouldn't necessarily be confined to the 7 or 8 items that John has identified. Additional items could be identified during the committee process or otherwise, but do you think it's, in your opinion or the committee's opinion, do you think that's something that ACUS should proceed with? And if so, I think we can proceed with it soon.
If I'm understanding your question correctly, Matt, are you asking whether I think it's advisable or whether we should take a poll of the committee about moving forward with John's proposal to develop a formal recommendation?
Correct. On the housekeeping type items, for lack of a better word.
Sure. My own view is that it seems like something worth doing. I think John's uncovered a lot of very valuable information, and that it's the kind of thing that that we normally would take on, even if we're aiming it at Congress rather than at the agencies themselves. I understand that's something that we've done in the past, and this seems like, housekeeping items like this seem like an appropriate area for us to address to Congress. My sense from the comments that I have heard is that there's a lot, people that seems to be a common theme. I mean, I know John Duffy in his comments was very positive, even if he had suggestions for alternative wording or what have you. My sense is that the tenor of the comments and questions today has been positive along those lines. if you'd like for me to take a poll of the committee before we let everyone go, we can do that. But I see Steph Tatum weighing in and saying that she thinks it's a good idea. I guess let me ask this question. If there's somebody who thinks it's not a good idea to move forward, given that I think that the tenor of the commentary has been generally positive, does anyone want to argue against moving forward with this? I'm not seeing any responses in that regard, so I would take that to mean the sentiment of the committee is that it's worthwhile to move forward.
Can I just make one comment?
Absolutely, please go ahead.
Just for marketing purposes, we need to come up with a better word than housekeeping to describe this. I mean, the thing is, I know this can seem like a small thing, some of these items, and yet, anything that can cause people to lose their right to judicial review is important. And I think an important function that ACUS has fulfilled over the years is to deal with these matters where the United States has managed to bat away suits for judicial review on grounds other than their merits by taking advantage of what seem like these tiny details that probably no one cares about, but that creep into the statutes, perhaps accidentally, and then cause people to lose their right to judicial review. And one of ACUS's most important recommendations ever was the one that said, you can just name the United States as a defendant, and we got rid of this whole unbelievably complicated fiction whereby you had to sue an officer rather than the United States itself. And although nothing really changed, that was a very important advance. So I know these things are small details, but they can be very important.
Well, so we have a couple of suggestions in the chat. Ron Levin suggests technical amendments, and I will admit that that was something that occurred to me too, although it also seems a little bit less grand than what you're describing. Alan Morrison suggests, I assume that's supposed to be anti-trapping legislation. We are at the end of our meeting. If anybody else has any suggestions in this regard, I assume John would welcome emails being sent to him.
Absolutely.
In conjunction with that. And in general, if anybody has any feedback that occurs to them later, I have no doubt that John would welcome that as well. But otherwise, I want to thank everybody for taking the time to join the meeting today. I think it's been a very productive one. I want to thank John for taking the time both to conduct the study and present it to us. And, with that, I will wish everybody a good evening. I think we're adjourned.
Thanks, John.
Thank you all.